everyone. My name is Maggie LaBranch-Gonzales, and I'm an attorney with Litherland, Kennedy & Associates. We're an estate planning and elder care law firm located in Campbell, California. So today's topic that I'm going to be talking about is whether or not your trust structure is too complicated. I know, it sounds like a crazy thing for an attorney to be saying it's too complicated. You need to make it simpler. It seems sort of like an oxymoron, right? But that's one of the things I want to talk about. And so really, it boils down to, number one, if you are a married couple, and number two, when was it that you first created your trust? Because if you created it 5, 10, 15, 20 years ago, then this discussion is probably going to be something you want to talk about. So the trust structure kind of boils down to taxes and how we want to think about structuring our trust when the first spouse dies, depending on a couple of factors. Number one being taxes. So today's tax exemption is $11.7 million per person. So as a married couple, one of the many or few benefits, again, of being married is that you can double that and pass almost $23 million completely tax-free to your beneficiaries. I know. Most people don't have that problem, but if you do, come and talk to me. We can hang out on weekends. So for many married couples, when they originally did their trust, the tax exemption was nowhere near $11.7 million. So they had to have this overly complicated trust structure to get that big tax benefit. Now, again, this is going to change, we know for sure, in 2025, whether Congress changes it again. I mean, my crystal ball is broken, but in 2025, it will sunset and it'll go back down to $5 million apiece. Adjusted for inflation, you're probably still looking at over $10, $11 million to pass to your beneficiaries tax-free. That's still a lot. Most families don't have that $11 million problem. So again, if you created your trust, 5, 10, 15, 20 years ago, it may be a little bit complicated. And now you may be thinking, what are you even talking about, Maggie? This trust structure? I have no idea what you're talking about. So let me share my screen with you. You can probably see this. Most people assume that they have this sort of a trust structure. We call it an A-only trust, a survivor's trust, lovebird trust. The essential point is one of you will likely die first, right? You're married. The goal always is to die at the same day holding hands. Ideal world. It doesn't always happen that way. One of you will likely die first. And at that point, everything will go to the surviving spouse. So 100% will go to the surviving spouse in the survivor's trust, an A-only trust, call it an A-only trust to make it really simple. That's what you think of when you think of typical estate planning. Many of my clients or non-clients who I review their trust assume this is the type of trust they have, even though they did it so long ago, because this is what they really want. This is what they're envisioning. This is what they like. It's simple. It's easy. The spouse gets everything. But if you created your trust 5, 10, 15, 20 years ago, you probably don't have this type of trust. You actually have what I would say is an A-B trust, an A-B trust. What does that mean? Again, one of you are going to die first at the first death. The surviving spouse is required to divide the trust into 2 sub-trusts. There will be an A trust still, so the survivor will have 50% in the A trust. And then there will be a B trust, sometimes referred to as a bypass trust, sometimes referred to as a family trust. Let's just say it's a B trust, right? It's a B trust. The B trust is the other 50% of the estate. So you still have the A trust, and now you have a B trust. The B trust is irrevocable. 50% of the estate goes into this B trust, into an irrevocable trust. You can see that here, right? You've got the A trust, you've got the B trust. And many couples say, I can barely survive on 100%. You're telling me I have to survive on 50%? No, not necessarily, depending on the terms of the trust. Depending on the terms of the trust, the spouse will get the income that is generated off the B trust, and they can also use it for their needs. Now, every trust is slightly different, but in general, that's how the B trust works. Now, I'm going to stop sharing. There are some negatives to having that trust structure. There are positives, but there are negatives. So let's talk a little bit about what are some of the negatives to having this B trust available. So number one, now you can imagine, especially here in California, where the vast majority of the wealth is in their home, their primary residence. So we just saw that AB trust structure you would have to split, right? Divide your house 50% into the A trust and 50% into the B trust, right? Okay, well, you can see how there might be some problems with that. What if you wanted to take out a refinance or something like that? You can't, because half of the value of the house is tied up into this irrevocable trust. The other negatives of having that B trust: there are no step up in basis for any assets that are in that B trust. That means your beneficiaries, even though they may get away from having to pay estate taxes, are going to have to pay capital gains taxes on any appreciation between the first and the second death. Now, again, you die on the same day or one day later, not going to be much appreciation. But if one of the spouses outlives the other one, and that value of the B trust increases, that's still taxes that could be avoided if you had reviewed your trust and modified it so that you don't have this B trust, or maybe a different type of trust. Again, there's because you're creating this irrevocable trust, there's going to be additional administrative fees, costs, a second tax return that are going to have to be done every year in addition to your own tax return, because it is an irrevocable trust. And it's irrevocable, no changes. You want to refinance? Too bad, you're stuck in that irrevocable trust. Tax laws change, maybe the beneficiaries change, irrevocable, no changes. And a big one, again, if you've got the bulk of your estate in that primary residence and you've had to now split it, if you have to sell the primary residence, any assets in that B trust are not eligible for the primary residence tax exclusion, right? That's the IRC 121 exemption. That's the 250 exclusion for the primary residence. So if you have a capital gains issue, you're not going to get that exclusion for the assets that are sitting in the B trust. Of course, there are some advantages to having the B trust. You have a taxable estate, you want it to grow tax-free, you want to have some creditor protection for the surviving spouse, or you have blended families. However, but all of these big things, there are now options to add flexibility to the planning to take some relief off of having to use the B trust. Maybe instead we give flexibility to the surviving spouse so that they don't have to create the B trust. Well, we'll see what happens at the first step. Or maybe they're using a different trust. Maybe they're using the C trust or the Q-tip trust or the marital trust, however you want to call it. The key here is reviewing your trust every 3 to 5 years to find out what has changed. The worst thing in the world is having a widow or widower come in, their spouse has just died, and having to explain to them that they are stuck, right? They have a legal obligation to create these two trusts that otherwise may have been avoided if they had just reviewed their trust in a timely manner and found out, yeah, this is way overly complicated. I get that we had to have it 10, 15 years ago, and this was the only way we could pass $2 million to our beneficiaries as opposed to one. But now with the tax changes, most people don't have that problem. So it's a really great opportunity to have, to come in to talk to an attorney who has the tax background, has the changes in the law available to see, is your trust overly complicated? Should we be adding more flexibility? And what are really the goals here that you want for your family, which may have changed over time? So again, I'm Maggie LaBranch-Gonzales, an attorney with Litherland, Kennedy and Associates, and thanks for joining me today.